Good evening and welcome to Introduction to Condominiums. My name is Richard Lee. I'm a condominium lawyer with Lee Associates. I'm joined tonight by two fabulous speakers, Bilal Mirza, who is a lawyer practicing with the condominium group at Simpson Weigel, and Sally Ann Duman, who's the Director of Condominium Management with Simpson Weigel Management. This might seem a bit trite, but I really have to emphasize that sessions like this, which are offered free of charge, can't happen without sponsorship. And we do rely on sponsors. The sponsors for tonight are Simpson Weigel Law and Lee Associates Condominium Lawyers. And a lot of what we're going to be talking about tonight's an introductory course. I'm going to get into a little bit about what we're doing and why we're doing it, but it really leads into other courses, obviously. And one that's coming up, and you might hear us refer to it quite a bit tonight, is the advanced or the enhanced director's course. And this one is actually, instead of 1 2-hour segment like we're doing tonight, it's actually 8 2-hour segments. It goes into much more detail, and that's coming up in September and October. So I really encourage everyone to look into that. And in case I forget to say so at the end of this, we're always looking for ways to improve these sessions. We've just actually revised a little bit of how we've do this session. So we'd like to hear from you whether we're doing it well or not, or what you'd like to see changed. Understanding, respecting, of course, the goal of the course. Now, I like to start by talking about the condo paradox. And you say, what is this condo paradox? Nobody told me about a paradox when I bought into a condo. And it's really, when you think about it, condos have been marketed for years as carefree turnkey living. Let's just move in and everything is taken care of for us. You know, the roof gets fixed, the driveway gets plowed. We don't have to worry about cleaning our windows, blah, blah, blah. And there's so much, so the condos have become the retirement communities of today and tomorrow. And we're not told, though, that marketing initiative is so effective, and we're not told that someone's got to step up and form government. Condos rely on the board. These are that's your elected government, and they're individuals who step up and put themselves in service of the community for zero pay, typically. And we're not told that. We're not told about the personalities that can happen in condominiums. You can have two almost identical physical condos side by side, which will have dramatically different personalities given the people that are in there. We're not told about the politics that come into play. And by extension, I can't say how many directors I've seen who step back, who decide not to put themselves in service because of the politics and that, which is really, really unfortunate. But it's a reality of condos. We're not told, for example, what's going to happen if nobody wants to be a director, and that's something that may or may not get more traction in coming years. So for everyone who's on tonight who is a director, I just want to say thank you, because everything that your communities can't work without you. We're in this. We service condominiums. We can't work without you. Very, very important. We received before the session many questions from you, and these are. I got to say, I'd love to know who you are tonight, because the questions were fabulous. The unfortunate thing is a lot of them are, again, at that advanced level. If we have time at the end, we'll try and get into them, because again, these are superb questions. So they have been heard. They are there. We do have them. As we go through this, if you have questions, type it into the Q&A. The way we like to work is because we're three speakers. When one speaker is on, the other two are in the background trying to deal with your questions as they come up in real time, in a way that goes out to everyone. So use the Q&A, not the chat. We want to make sure they go out to everyone. And if there's a particular good question, it'll come up at the end of the session so that the speaker can deal with it orally. Why do we care about education? Well, education or lack of education had been identified as a major cause of conflict in condos or anything. If we when we forget history, we're deemed to repeat it. We don't want to do that. We're seeing mandatory education being introduced for directors, for managers. We're finally seeing licensing of managers. We had hoped to see some minimal mandatory education for owners. Didn't get it. We can always hope. CCI as an organization has been involved in educating communities for almost 40 years, since 1982. I think CCI does a fabulous job at it. The Ontario government, by contrast, has been involved since November 1st, 2017. So that's what, 3.5 years? I think we do a good job. But I want to stress for tonight, this is an introductory level course. You're going to be seeing a lot of there's that star over here, more in advanced. And again, we can't help it. There's just not enough time in one session to go through everything. And lastly, I want you to recognize that what we're talking about is general. Every condominium is unique. There is no say, you can't say all the condo docs, and Bill is going to be talking about condo docs, declaration bylaws, rules. You can't say they're all the same. Every condominium is unique in some form. So we do have to generalize a little bit. So what is a condo? And in its most basic sense, a condo is just a way of owning in common and communal ownership of property. That is really all it is. It can be residential, commercial, it can be mixed use, it can be docks, it could be boats even. Actually, I haven't seen a boat one, but why not? But it could be almost anything. And typically a condo is divided into units and common elements. The only type of condo that doesn't have units is a common element condo, which I'll show an example, which has only common elements. When you buy into a condo, you're buying your unit and you're buying a share of everything else, of the common elements. And that share in the whole is called your common interest. And I don't know if you've ever noticed that, if you've ever flipped through your declaration, you get towards the end and you see typically it's Schedule D, it'll have common expense proportion, common interest proportion. And that's the common interest is your share that you own. I'd like to go into a poll at this point, and Katya, if you could launch that poll. Katya is our tech person who's behind the scenes, who's making sure everything runs fabulously. So what I'd like to do is get into what is a freehold condo. And the reason I like to start with this is I find this term freehold to be a little bit misunderstood. And I really want to challenge you to try to understand, answer that question. How do we know what we don't know? And to do that, you really have to open your mind, perhaps forget about some of the assumptions you make and look at things perhaps a little bit differently. So I want to start with this phrase freehold, because I tend to hear it misused very often. And it's unfortunate because it is a legal term. So the poll is, which of the following does not relate to a freehold condo? Oh, I've already got the results. Okay. Oh no, they're still coming in. Katya, you're showing the results before they're all in.
No, you'll see it. It's live. You'll see them live as they go in.
Oh, okay.
These are not the results yet.
All right. So, so which of the following does not relate to a freehold? And it's units which include front and rear yards, units which include the roof foundation, units include the driveways, units sit on land leased by the condo. And the second one, which of the following best describes a freehold? Best. Units include front and rear yards, unit include the roof foundation, unit include driveways, units sit on land owned by all the owners in a condo corporation. Okay, I'm
going to give it another 30 seconds. We have less than half.
Yeah. And don't be shy. We can't tell who's saying what. Don't be afraid of being judged. I really want to try and make a point in this. And again, challenge everyone just to open up their minds a little bit. Okay, have we got the results?
Yep, they're up.
Okay, so which of the following does not relate to a freehold condo? And its units sit on leased land. Yes, and that's 85%. That's amazing. The term freehold means you own the the land. That's all it means. And so the second question, which best describes a freehold, and 46% of you got it, the unit sits on land owned by all the owners in a condo corporation. That is really what it is. And you'll hear, and the other points come up. The unit sits, or the units include the front and rear yards. Sure, it does, but it doesn't have to in a freehold. It includes the roof and foundation. Sure, but it doesn't have to. And the reason I like to stress this is I see freehold being used to describe, I use the term lot line. It's not a legal term. It's where the unit boundaries go to include the front yard, rear yard, the roof, the foundation, etc. That's just a condo with different unit boundaries. And a freehold means you own the land. So thank you very much, Katya. How do I stop this now? That's off. I'm not moving forward for some reason. Oh, there we go. So freehold condos are any type of standard condo. And if you were registered before 2001 or May 5th, 2001, you were a standard condo. That's all there was. It could be phased, vacant land, or common element. Leasehold is everything else, but it's just a condo that sits on leased land. So standard condo could look like your typical townhouse condominium. The unit boundaries could be the inside of the drywall or could include the front yard. The unit boundaries could be the top of the drywall on the uppermost ceiling and the top of the concrete in the basement, or it could be the roof and the foundation. Doesn't make any difference. A phased condo is one that's built in phases. So same condo, just built in phases. And it results in a standard condominium. And what it's planned this way, and it's planned to have a declaration amendment done as units sell, and that second phase gets rolled into the first, and it becomes one condominium. Not to be confused with condos which have shared facilities organized through a shared facilities agreement. That's two different things. A common element condominium has got only common elements. So in this case, it would be the roadway and the park might be the condominium. The units or the homes or however they are outside. These are called parcels of tied land or pottles. But they are not technically inside the condo. And there's a little bit of, I want to say controversy, but it's not really controversial. There's a lot of provisions in the declaration that says the condo still has to enforce. And that it sort of worries me because it's technically correct. I think there's a case that supports that. But the condo is made up, in my view, to be almost minimalistic, which is the road and the park in this case. Vacant land condo is, imagine a standard condo without any buildings on it. And then you build. It could be, we're seeing more and more gated communities with single family homes on, and that could be a condominium. So in this case, it's all a condominium. The unit is front yard, backyard, but nothing's there. And then very often the developer will build something for them, for whoever buys it. And then lastly is leasehold. And you'll notice the front of this picture. I like this picture because the front is a church or an old church. And leasehold is a condo that sits on leased land. And very often it comes about because you've got some entity, often it's churches or universities, which own land, but they can't do anything. They can't sell it, but they can lease it. So we're seeing these popping up where a condo sits on leased land. Long-term lease could be 40 years, 99 years, etc. And then you buy a unit in that. And that's all I'm going to say by way of intro to this. I'm going to turn this now over to Bilal, who will take this forward.
Thank you, Richard. Good evening, everyone. I'm happy to be speaking to you today. This is the introduction to condominiums, and I'm going to be talking about 3 different sections. And I'm just going to share my screen so you can all see it. The first section that I'm going to be talking about today is directors' responsibilities and governance. under the Condominium Act. The overarching theme of my part of the presentation will be references to the Condominium Act and the various other documents that pertain to condominiums, which are all also, of course, set out in the Act. Also, I'll be talking about how the Act and the legislation under it and the various rules and regulations impact your role as a director in a condominium. On a holistic level, the Condominium Act, it's largely a consumer protection legislation, as Richard also alluded to, and it's essentially enacted to protect the rights of unit owners in various ways. You will see this in minimum standards that condominiums have to adhere to. You will see this in mandatory disclosure requirements that when one is purchasing a used residential condominium unit, the law requires for there to be a disclosure by the condominium in a status certificate of any outstanding issues, outstanding condo fee arrears, litigation, etc. Like a whole set of issues that are by law required to be disclosed. The same thing goes for directors. As many of you would be familiar that when you're taking on the role of a director, you're required to compulsorily disclose certain information, conflicts, etc. There's a prescribed form that's required for that. So that is the theme of the legislation, and that's something you should keep in mind when you're reading and reviewing the legislation for context. That the overarching theme is consumer protection. The legislation makes it worthwhile and a viable option for people to invest in condominiums and buy into condominiums. As a director, you should be familiar with the structure and the process of the Condominium Act. You should be familiar with the responsibilities of directors and also the various governing documents that apply to condominiums and how they secure rights and expectations of directors and unit owners and other parties that come into play in condominiums. Let me take you to my next slide here. Governance. The legislation, the Condo Act, deals with how is a condominium governed. First of all, it's Section 27. It requires that a board of directors is to manage the affairs of the corporation. So you're looking to the board for essentially, spearheading and running the affairs of the corporation. That's under Section 27, subsection 1. The next question is, well, how does the board conduct the business? Section 32, sub 1 specifies that the board is to transact business of the corporation at a meeting of the directors at which a proper quorum of the board is present. So that is how the board operates. The legislation requires that the board meet periodically. There's certain requirements and parameters as to how often, in what circumstances, and when does a board meet. And it'll be in the Act and also supplemented by bylaws that we'll speak about. But essentially, it's by way of board meetings. So that's important to note. Sometimes it happens, and Sally can attest to this as well when she speaks, that many decisions are made by board members by way of email circulation and consensus by email, which is fine, but it has to be ratified by the board in a subsequent meeting then in its minutes for it to be official condominium board business. So that's something that you should also bear in mind, that business has to be transacted at a meeting, and anything that may happen between the meetings should be properly documented in the subsequent meetings minutes for it to form part of the official record and be binding. How are meetings called and held? That's an important aspect of the board governance as well. You have to bear in mind that the Act and the bylaws require that written notice has to be given for the board meeting. And this can be by personal mail, courier, fax, email, etc. And then the notice must be given at least 10 days prior to the date of the meeting, unless stated otherwise in the bylaws of the condominium. The notice must also state the time and the place of the meeting. So that's important. And the other thing to note is that every condominium corporation must have, in addition to its board of directors, at least a president and a secretary, normally, of course, appointed from the directors themselves. And these offices are then notified to the condominium authority. So those are the two offices. The next question is, who can be a director? So there are certain minimum requirements that are set out in the legislation. Number one has to be at least 18 years of age, cannot be an undischarged bankrupt, capable of managing property, the Subsidy Decisions Act. You might then specify more restrictions or requirements in your bylaws. These are just the basic requirements. For example, the legislative requirements do not necessitate that the board director be also a unit owner. So essentially, it can be a non-unit owner who doesn't own or live at the condominium premises who can be a board member under the legislation. But of course, you can supplement the director prerequisites in your bylaws, and you can put that in place. There's also the mandatory training that Richard mentioned earlier. So that's now required that whoever takes on the position of a board is required within 6 months of election or appointment to complete this online course that the CEO offers. And then it's valid for 7 years, and then you renew it. The condominium corporation ordinarily would pay for it, and existing directors who were grandfathered into this requirement had 1 year to complete it. And I mentioned briefly before, there are also now mandatory disclosure requirements. So as a new director, you're required to disclose if you have any direct or indirect interest in any of the condominium corporation's assets. If you're convicted of any offense under the Act, or if you have condo fee arrears for more than 60 days, that's also to be disclosed. And a usual term for a board member may be for 3 years, could be less. You specify that in your bylaws. Section 17 of the Act sets out the objects and duties of the condominium corporation and how the board manages those. The requirements in Section 17 are threefold. First of all, the board is to manage the property and the assets of the corporation. Secondly, the duty is to control, manage, and administer the common elements, and a duty to ensure compliance with the Act, declaration, rules, and bylaws. We'll talk about those documents in a bit. Decisions are ordinarily not subject to unit owner approval, except when they are required under the legislation. So that's something important to note as well. As I said, there's a requirement that the board has the right to insist upon the compliance of these condominium documents, and that the owners comply with those regulations, rules, and bylaws that the condominium may have in place. So that's something that has to be borne in mind. Section 37 then sets out the standard of care with respect to what is the expectation from a board director. The legislation provides that the board member is required to act honestly and in good faith. That's the first part. And then the director is to then exercise the care, diligence, and skill that a reasonably prudent person would exercise in comparable circumstances. So that is the threshold or the test that one would apply in determining if the director is discharging their duties and obligations properly and in compliance with their legal requirements. So that's what you would look at. And of course, there's a lot of case law, a lot of judicial pronouncements which expand upon this, but at a very base level, the legislation provides this as the minimum standard of care that's expected of a director in a condominium corporation. So that's something important to keep in mind. A director, usually the requirement is that they uphold and abide by the decision of the board, so they have one unanimous front. That's something that the board should strive towards. And they should speak as one complete unit, regardless of split decisions. That's something, again, from the commentary on these sections. And as I mentioned, they're required to exercise care, diligence, and skill that a reasonably prudent person would exercise in comparable circumstances. So it's an objective test. And that's also something to keep in mind when you're applying this or thinking about this. The other thing that's important to note is that Section 37, subsection 3 specifies that a director may rely upon the opinion of a lawyer, engineer, auditor, or other individual whose profession and experience lends credence to their opinion, and the directors cannot be held liable if the decision that was based upon that opinion does not turn out well. So that's good, because as a director, if you're deferring some decisions to a professional who's in a particular field giving you professional opinion, then if it turns out that the decision or that opinion was not in the corporation's best interest, directors are absolved of personal liability. But conversely, it's also important to note that another way of reading this provision is that in a situation where the corporation did get outside advice from a professional but decided not to use it to its detriment, then of course they would be liable because they had advice which said the contrary. So again, something to keep in mind. Okay, I'll go on to my second section now. I'm not sure if there are any questions that have trickled in. I don't see any. I'll keep moving along. So the second section is the condominium documents.
Sorry, Bilal, if I could interject here.
Sure, good.
There was one question that was brought in earlier that would apply to what you just said. These are the questions that were submitted before the meeting or before the session started, and it's when directors break the rules, what consequences are there? It's a great question.
Mm-hmm. So there is provisions in the Condominium Act which provide for remedies. There's a whole chapter in the Act, Richard, as you're aware, which deals with the various remedies that a unit owner may have. There's a remedy for oppressive conduct, among others, which one can enact if and rely upon if the director is falling short of the expectation and their standard of care, if they're not meeting it. That's from a very legalistic standpoint, but from a practical standpoint, if the unit owners are unhappy with the director, there's a process which I'll also mention in my third section today with respect to what unit owners can do. And one of the things that unit owners can do in that situation is perhaps requisition a meeting to have an election. Re-election to see if the director should stay or not, and that's something that's within the unit owner's consent by majority.
If I could just add to that,
sure.
Board condos are run by the boards. They're your elected government. So if something's not being done, then owners. There's remedies now through the court, etc. The condos got a duty to uphold the act. So think maintenance and repair. There's a case, Ryan and YCC 340, where the windows weren't being done on time, and the condo was being held in breach of its duty to maintain and repair. That's the board not doing what it had to do. So there are remedies. Sorry, I'll let you carry on.
That's right, Richard. And then there is, of course, it's a hotly contested, litigated area, of course. And so I saw another question come in with respect to email consensus. Is there case law on whether board is present on an email chain, therefore the board doesn't have to ratify the next meeting? I'm not sure about the case law, but the general rule, as I said, is that if consensus or decision has been made by way of an email exchange, the rule that you should follow as a good governance practice is to have it ratified. And if it's not, then like maybe even in subsequent meetings you can catch up to it, but good idea to have it ratified in a subsequent meeting. So know your documents. So I mentioned the Condominium Act, and that's what we're talking about right now. We spoke about some of the sections under the Act, the regulations under the Act as well, which supplement the Act. So that's at the top of the food chain with respect to what applies to condominium. You're always looking at the Act for answers, and that's the one which has all your, everything else devolves from it. The other document that we'll talk about are the declaration, description, the bylaws, rules, and policies. Many of you, of course, will be familiar with these documents. These are documents that you may often refer to or have seen or talked about in your directors meetings. And the idea is just today talk about them in a little more detail as to what are these documents, how do they come about, how do you change them, etc. Before I do that, though, I have I believe a poll that I can put up, and Katya can share that with you, which will basically just be 2 questions about just general knowledge about which document are you looking at to make certain changes. So both these questions are scenarios where there's an existing condominium and the board is considering certain changes. The first change is that no unit owner should have more than 2 pets per unit, and all dogs should be on leashes. So they're considering this new rule. Currently, there is no rule which, or there is no policy or any kind of restriction on how you have and keep pets, and how many pets can you keep in your corporation. Which condominium document should the board consider to include these restrictions? That's the first question. We'll give you the options for all those documents that we just looked at, and a combination of them as well at the end. And the second question is that the board is considering amending the proportionate contributions each unit makes for its condominium fees. So how much condo fees does each unit pay? The proportionate interest ownership and the proportionate interest fee. Which document should the condo consider to amend, to submit, and to put in place this amendment? So I'll let you all answer that, and we'll see what happens. So Katya, do I see some sort of a result on my screen once everybody's?
Yeah, I will share the results at the end.
Perfect. Thank you very much. So the idea really is for you to think about the different documents and which documents or a combination of them are you looking at for certain. If you're number one, looking to see where a particular thing might be, just to kind of find an answer to a question. And then secondly, if you're looking to change something, which documents would you be looking to change or amend to put in place a new, decision that the board has come up with to deal with certain aspects of the condominium. So that's really the idea. Okay. So B, C, and D, declaration, bylaws, and rules, is the correct answer. So you for changes to documents with respect to pet restrictions, you would be looking at B. You could put it in the declaration, you could put it in the bylaws, or you could put it in the rules. You could also put it in the policies, but it makes more sense to perhaps one of these 3 documents to be amended for it, because it's just the better location for that change. Changes to common interest ownership, and the overwhelming answer is declaration. That is the right answer, and we'll talk about that. Right. So we'll talk about declaration and description first. Declaration of the condominium is the second document in that hierarchy that we looked at on the previous slide, which is basically right here under the Act. So that's the second most important document which governs the condominium. You're looking at basically the document which creates the condominium. It's much like a constitution or the articles of incorporation that a corporation may have, a business corporation. Every corporation has one of these. It sets up the use of each unit, the boundaries of units, and the percentage ownership for each unit, like we discussed just now. The description, on the other hand, which is also known as the condominium plan, this is a plan of reference or a reference plan of survey in the manner of a condominium plan, and it's much like those documents that Richard had on his screen when he was showing you the different kinds of condominiums. Those are all condominium plans. They're also called descriptions in the language of the Condo Act. So for declaration, the other few points I'd like to quickly make is that it must have these items that are referenced here. They're the bare minimum requirements. It may also have things like a statement of what constitutes the common expenses, restrictions on leases, for example, restrictions on occupation or restrictions on use of units, and the maintenance repair obligations between the condominium corporation and the unit owners. Who is maintaining, repairing what? There would be default obligations in the Act, which you can then amend or supplement, change by way of Condominium Act to the extent that you're permitted to do so. So the maintenance repair obligations, if you're wondering who's supposed to be maintaining something, repairing something, you're looking at the Condo Act in conjunction with the declaration to get your answer. It must be consistent with the Act, and there's no obligation for it to be reasonable. So you can have provisions in there which may arguably be unreasonable. And you might also find more and more pet prohibitions, parking, student noise, and other use of amenities issues dealt with there as well. It's registered on title to the condominium, so it's something that's a title document. Any time a condo wishes to amend the declaration or the plan, it has to get at least 80% or 90% of the unit owners to vote in favor of that change, depending upon the nature of the change of the condominium. So it's a very high threshold that one has to attain to make amendments to the declaration. The bylaws are essentially a document which set out how a corporation, a condominium corporation is to be run. It's basically more to do with procedure. So if the declaration says what is a condo, the bylaw will answer the question, how does the condo work? So things like the organizational bylaw will set out in detail, the workings of the board, the requirements of meetings, etc. So it'll go into a lot of nitty gritty about essentially how the business of the corporation is run on a day-to-day basis. So that will be usually the bylaw number one, the general governance bylaw. You might also have a standard unit bylaw which describes the unit. You might have a borrowing bylaw. You might have occupancy standard bylaws, assessment bylaws, code of ethic bylaws. It might be mediation or arbitration bylaws. You can have many different kinds of bylaws. The Condo Act provides for certain kinds of items which are only to be specified and set out in bylaws. But we're seeing more and more items which are now being addressed by way of bylaws. So that's bylaws generally, but like I said, the one of the most important ones, usually which is registered as bylaw number one, which is the organizational bylaw, which will have a lot more detail about the workings of the condominium. It must be reasonable in comparison to what we discussed in relation to declaration. So you can't put in provisions in there which might be patently unreasonable. Must be consistent with the Act and the declaration. Any time you want to amend or repeal an existing bylaw, you have to get a majority of all unit owners. So more than 50% of the unit owners have to consent at a meeting of the owners in order for a bylaw to be amended, or for you to repeal a bylaw, or for you to institute a new bylaw. So all three of those things can only happen by a majority of the unit owners voting in favor of it. And this is also something which is registered on title, much like the declaration that we saw. So if you want to get a copy of it, you can't find it anywhere else. You'll always get it on title. And for it to be properly effective also, once a condominium passes a bylaw, has to be registered on title, much like the declaration. If that step's not taken, then it's not valid. So that's just something to keep in mind. Rules. Rules basically answer the question, how do people generally live, or unit owners and residents generally live at a condominium? That answer is generally answered by a question generally answered by the rules. The rules are basically under the Condominium Act are to be enacted. Section 58 provides to promote the safety, security, or welfare of the owners and the property, and to prevent unreasonable interference of the use of the property. So anything under those main umbrellas, you're passing, the board of directors is passing rules to set out and deal with various aspects of, how do people live at the condominium. That's generally the intent. Standards of behavior in community are dealt with it. Noise, use of facility are some examples, like if there's a party room or a rec room, swimming pool, etc. You may have rules which deal with, how do you book it? What times is it available? things like that may be set out in the rules. Again, for things like noise levels and other things, these may be dealt with in the rules. As I mentioned before, like another example might be parking. Pets is another example, things that you might see in rules. They have to be reasonable. That's another requirement. It must be consistent with the Act, declaration, and the bylaws, because they're below those items in the hierarchy of the documents that apply to condominiums. They're passed by the board. They don't have to be passed at the unit owners meeting. But once the board passes it, they have to give notice to all unit owners, and then they're effective 30 days after the date the rules have been mailed out to all the unit owners, unless the unit owners requisition a meeting to challenge the rules, and in that meeting, then there's a vote. If the majority votes against it, then the rules are struck down. But if there is no meeting requisition, and if at a meeting there is no majority vote to strike them down, then the rules become effective 30 days after the date they've been sent out to all unit owners. Rules, in contrast to the other documents we looked at, are not registered on title. So if you want to get a copy of that, you have to get a copy from the board, as the unit owner or the property management may have it, but it's not something that's required to be registered on title, and they're not in fact registered on title. Policies is another area which you may come across. Normally, these are documents which are made for processes for the inner workings of the condominium, things like the collection of fees and banking matters, bookings of various amenities may also be set out in policies. These are just documents which are made by the condominium, just set out how things are done from a procedural standpoint. It's good to have these. The one important point that I want to make about rules in comparison, and policies also in comparison to declaration and bylaws, because they're easier to enact and change, it's desirable to keep amending these things as time passes, so they accurately reflect the condominium. If people have, if the people who live in a condominium have changed over the years, or the demographic has changed, or their requirements have changed, the rules should also change to reflect the people who live there. And that's a good exercise for the board to conduct every few years, to see if their documents adequately reflect what's actually required at the condominium. Some of the other documents which are not mentioned here, I'll quickly reference those. There's shared facilities agreements may also be applicable to condominiums where there are two adjoining condominiums which have shared facilities. There might be an agreement registered and title which both condominiums are bound by, which set out what those shared facilities are and how they pay for them. Cost sharing agreements are also called reciprocal agreements, and also easements which go hand in hand with that. So condominium may have easements either over adjoining lands, or it may be subject to easements in favor of adjoining lands, or utility easements as well. So those are things to keep in mind, which might be of importance with respect to documents that apply. Okay. Generally about these documents, keep in mind that it's a good idea to have, as we saw before, the board is required to enforce these documents, and that they're required to compel that unit owners abide by them. So you have to ensure that you're actively and proactively communicating the needs and requirements in the document. And when the Act provides, and when there's a breakdown, then there's procedures to deal with that, mediation, arbitration being the last resort. But there's always through otherwise through correspondence or through the property management, or otherwise you can try and resolve issues before it escalates to that level, of course. Okay, that takes me to my third section. I'll just continue on. Unit owner meetings. So it's useful to think about unit owners and what the purpose of the meetings is. So the unit owners basically are the people who, much like in an elected government, they're the ones who are electing people to run and conduct the business of the condominium. So they're basically the voting public who elect the directors, who are the elected government. And then there are other outside players like property management, and then lawyers and engineers may also come into play from time to time. but the unit owners are really the people who are voting and the real decision makers at the end of the day, because they're the ones who are putting the directors in office to make decisions on their behalf. And if they're not happy with them, as I mentioned, it's a representation of the unit owners at the board level. There are three kinds of unit owner meetings, and they're mandatory and they're also voluntary unit owner meetings. Annual general meetings are under the Condominium Act, Section 45, Sub 2. They're required to be held within 6 months of every year-end, fiscal year-end date of the condominium corporation. So that's the requirement for annual general meetings. Every corporation is required to have one each year. So that's that. But also when it's initially registered, the first meeting is supposed to happen within 3 months of registration of the condominium, and then thereafter within 6 months of each fiscal year-end date. That's the AGM, and I'll talk about that in a little more detail. And then there might be information meetings. These might be meetings where the board is considering some sort of a change, some sort of a major construction project, or some other, let's say, change to their documents, something which they want to see, either provide information generally to the unit owners on an important subject, or get some ideas to consensus and how much they can get consensus on a topic before going down the path of actually making some serious changes. So they may also be called town hall meetings. So basically, they're just meetings where you're setting up and sharing information with the unit owners. Requisition meetings are meetings that are requisitioned by unit owners. So that's something I'll talk about as well briefly. So with respect to the AGM itself, the first kind of meeting, what happens at the AGM is that it's an opportunity, number one, for communication between the board and the unit owners. It's an annual occasion where everybody sees everyone. These days, of course, like we're seeing each other most of the time through an online meeting. That's been the norm in the past year or so. But of course, used to be in person a lot before then. Some of the prerequisites of AGMs are that there has to be a financial report that's presented by the auditor on behalf of the corporation for the last fiscal year. The auditor will then be appointed for the upcoming fiscal year. There will be discussions around the budget for the upcoming fiscal year. It's presented ahead of time in the documents in the notice of meeting. There might be an election for the directors if there are any vacancies that have come up for the year. So you may have an election. And normally there might be a report from the board or the property management with respect to issues of significance in the past year. And there might be some discussion around them with the unit owners. So that's the AGM. It also should be noted that only topics that are set out in the notice of meeting can be properly voted upon at the AGM. So if an issue comes up from the floor, it can be discussed, but you can't vote on it unless it was something that was included in the notice of the meeting. The second important kind of meeting, as I mentioned, which is third on the list here, is requisition meetings. So unit owners of at least 15% of the units may requisition a meeting at any time. So there's a proper form. There's a prescribed form, in fact, that they have to fill out and sign, at least 15% of the unit owners. And then once it's been signed by the requisitionists, they have to state the nature of the business that they're looking to discuss at the meeting. And then they have to deliver it to all unit owners in the same manner as the AGM notices are sent out. The board must then respond within 10 days of receiving the requisition, and they may either call and hold the meeting. They may not respond, in which case the meeting is deemed to be called, or they may respond and advise that they will not call and hold the meeting and provide reasons that, for example, the notice itself was defective. So that's one way that they can deal with it. So that's requisition meeting. So that's, like I said, if there's something that at least 15% of the unit owners want to discuss, they may bring it up at a unit owners requisition meeting, so it can then be discussed. What can be decided at a requisition meeting? Anything that can be decided at a unit owners meeting at the AGM, it can also be a topic for discussion and vote on in a requisitioned meeting. For example, things which like the amendment or repealing of rules, removal of directors or auditors, etc., are some examples. The other meeting that I mentioned, as I said, was under section 45 of the Condominium Act, subsection 4, which permits directors to hold information meetings or town hall meetings for any purpose. And it's a good idea to have these if there's a major construction project that the corporation's considering, or if it's looking to enact some new rule which they think may be controversial, may give rise to friction. It's just a good idea to get some input from unit owners, just kind of see what the general consensus may be by doing these information meetings. It's a good cost saving and planning opportunity to do these kinds of meetings, and it gives the more communication and open communication the board has with the unit owners, the easier it is to do the work that the board's required to do. The last thing I'll discuss is with respect to the notice requirements of AGMs in particular, and how are you supposed to send out notices. So there's two notices that go out when you want to hold an annual general meeting. The first notice has to go out at least 20 days, which is this notice is called the preliminary notice. It's a prescribed form, has to go out at least 20 days before the actual notice of the meeting. So you're sending out this preliminary notice and then putting in certain information in this prescribed form. And then the owners have a deadline to give some input, which is a day before the notice. And then on the 21st day, in this example, is when you're sending out the actual notice of meeting, which then, like I said, comes after the preliminary notice. And then the notice of meeting has to go out at least 15 days before the actual date of the meeting. So if you're planning to have an AGM on a certain date, let's say in July of this year, you're looking at maybe end of July. So you have to plan ahead. You have to kind of, plan backwards from that date to see what dates you'll be sending out your notice and preliminary notice, and build in some buffer dates, because there's a lot of case law also around the definition of at least. So that's where you have to do some planning around sending out notices for meetings. Okay, and that's everything that I have in my end. I will hand it over to Sally to take us through the next section, which is property management. And Sally and Duman, of course, she's from Wilson Blanchard Property Management. And I just want to clarify that from the beginning, the introduction. Over to you, Sally.
Thank you, Bilal. Sorry, I'm getting caught in some sunlight here. I am going to talk about property management, and we'll start by sharing my screen, I hope.
Well, can you stop sharing your screen, please?
Oh, there we go. I don't think mine is sharing yet, is it? Katya, can you help?
No, it's not. So just hit share screen again.
All right. We'll
and then make sure you click the screen you'd like to share. And then hit share.
And share. There we go.
There we go. Yep.
Okay. So regardless of the type of condominium or the size, all condominium corporations need to be managed. Property management includes oversight of building operations, repair and maintenance, financial and legal obligations, and the day-to-day needs of the residents. So the declarant, when preparing the first year operating budget for a corporation, generally sets the initial form of property management. And there are a few options. The board of directors ultimately has the responsibility to manage the property and assets of the corporation on behalf of the owners, but that can be accomplished in a variety of ways. One approach is self-management. Another is a direct hired manager, contract management, or a hybrid approach. So I believe Katya, we have a poll coming up. If you can post that. And sorry, Katya, I'm having trouble. I've lost my screen. Oh, there we go.
On the bottom left of your screen there on Zoom, you can see two little arrows, and that will help you slide. Go to your next slide.
Yeah, no, that's okay. I had lost the poll.
Oh,
So,
I see.
okay. So the types of management that we have now in attendance tonight, we're still getting the poll results in.
Give it another 20 seconds.
Yeah. Once we've got those results, we'll talk a little bit about the differences between those different types.
Okay.
Okay. So it looks like the vast majority, we've got what, 77% of those in attendance use a professional management company. We've got a few hybrid and a few self-managed and one with a direct employed manager. So thank you very much. That's interesting and good to know that we've got some people from the different types of management and styles of management in attendance tonight. So the differences between the different types of ways to manage a condo corporation can be broken down into the benefits and the drawbacks. So first of all, the self-managed condominium corporation that refers to where the board of directors carries out the management duties. A working board is definitely more work than a governing one, but it can be appropriate in some circumstances. Some of the benefits might be a sense of accomplishment because it's more of a hands-on factor for the board. There is perhaps a more personal touch to having the board directly look after the functions of the manager. And there may be some cost savings, obviously, from not hiring a manager. The board absorbs some of that expense that would be paid out for a professional manager. However, there are also drawbacks. Of course, depending on who is on the board, the necessary level of expertise may not be available for condominium administration and the other duties. Potentially, there may be a higher use of consultants, which would incur more costs. Unit owners may not be comfortable speaking with a board member about personal matters. If there's an issue with maintenance fee payments or something to that effect, some unit owners may prefer not to be talking to their neighbors who are the board members about those personal issues. There's potentially an issue with a continuity of corporation records being transferred from one board member to another as they change at each AGM. And of course, the directors will have substantially additional responsibility and liability, donating a lot more of their time. And also, it's good to be aware that if a board member receives compensation for his or her services on the board, that would be considered a manager's position, and that person would need to be licensed in order to be paid to perform those duties. The next option is the direct employee, and we do have one corporation represented here who has a manager who's been hired directly by the corporation. So that person becomes an employee of the corporation. And the benefits to that is that the board controls the salary as opposed to the management company setting a salary for their manager. And the board has more control, well, total control over the management function. The drawbacks of that is that there's a cost to training a manager. There's a cost and a time factor to having to replace a manager they are, take time off sick or have vacation time. There's also no senior person for that manager to go to, if things go wrong or there's an unexpected issue that the manager isn't familiar with or hasn't encountered before. There's no one to go to for support and more senior knowledge and experience. There would have to be, usually it would also mean hiring a separate company to do the accounting function. Normally the manager themselves don't take care of that function. And then lastly, sometimes insurance is, the insurance premiums are increased, and directors and officers liability insurance is increased when there isn't a professional management company or team behind the scenes. So having a property management contract in place is obviously the most popular and the most used by condominium corporations. The benefits of hiring a management company: there is less volunteer time on the part of the board members. Boards can focus on governance rather than the management function itself. There's potential cost savings, as management companies generally have contact with contractors who are able to provide better pricing because they know they're potentially going to get much more business and be exposed to more opportunities through a management company. Obviously, the senior support, the experience of other managers and other support people in the company. If the manager's off sick or takes a leave of absence or is on vacation, there's generally people to back up the vacancy. There's an established chain of communication. There's administration, financial, and legal knowledge. There's the benefit of having a third party to enforce rules and the provisions of the corporation's governing documents. There's a continuity, and the management company already has errors and omissions insurance in case of error or something being overseen. So the drawbacks, though, are the board is obligated to follow the property management firm's overall processes. And they're obligated to use the property management company's banking institution. It's also a little more difficult to establish an employer-employee relationship. It's not quite the same when the manager doesn't work directly for the board. And final decisions regarding staffing is not made by the board. It's made by the management company because they are the employer. And then lastly, the hybrid version is self-managed condominium supported by some level of professional management, usually for bookkeeping, financial records, and sometimes a consulting function as well. This is becoming more common in the smaller corporations as the boards realize that being self-managed is more difficult than it may on the surface seem, and they do realize that help is needed very often. So, okay. So what are the roles and responsibilities of the board and manager? Boards need to understand the vision of their corporation. What is that vision? Is it that they want to be the best in the neighborhood, a high-end condo, or are they looking at clean, decently managed with lower costs? And board members need to test the decisions you make against that vision. So governing your condominium corporation, whether it's self-managed, direct hire, contract, or some variation thereof, should always be a team effort between the manager and the board. If you're self-managed, then it's between the assigned director and the rest of the board members. But the board has to determine when it's important for them to get involved and when they should allow the manager or that assigned director to handle the situation. So we first need to determine if the concern is really a board issue or something that's better handled by the manager. The board handles issues that affect the whole community, the whole corporation. The manager handles issues that affect individuals. The board dictates what the corporation will do. In other words, policy. The manager implements the policy. The board handles situations and issues that are dictated by law or are requested by the manager. So
Ellie, sorry to interrupt. There's something
Yes.
popped up on your screen.
I'm sorry?
Something's popped up on your screen.
I'm sorry. Thank you very much. So unfortunately, many situations are not clear when it comes to responsibilities, and it's no wonder that conflicts exist. It's important to understand that directors do not take action as individuals. They must act as a team. It's like Bilal had said earlier, that board members cannot act individually. They must be constituted board meeting in order to make decisions and act together in the interest of the corporation. So acting as a team, the boards set policies and goals for the manager to implement and achieve. Good communication is key, so that when the responsibilities get confused, the board of directors and the manager can resolve the problems. The board sets a clear vision for the property's future, and the manager helps achieve that envisioned future. So let's talk a little bit about some examples between the responsibilities of the board and the manager. Using the three items that are noted on the slide, there's a lot of examples that we could go through. I'm not going to go through all of them, but if you have questions about specific situations or examples, we can certainly touch on them. But the slide in front of you talks about policies as the first item. So the manager assists the board to set up new bylaws, rules, and policies, including evaluating current processes and making recommendations for change. The manager's responsibility is to provide the board with information so that the board can then adopt a bylaw, rule, or policy, making an informed decision as to what can be done, what is legal, what is recommended. And then once the board approves the policy, sets the policy, the manager implements it. So the manager is the beginning step and the last step, and the board approves in between. Another example then is the budgets. I can't tell you the number of board members who have said to me at one point or another, well, you prepared this budget. This is your budget. This is, your management company's budget for our corporation. And I can't stress enough that the budget is the corporation's budget, and it is approved board of directors. The manager's role, again, is to provide information, to make recommendations, to assist the board in coming to an informed and appropriate decision for the condo corporation, but it is the board that approves the final budget document. So the manager oversees the collection of maintenance fees as per the board's policy. The manager manages the expenses so as to achieve the maximum economic benefit to the property. And the manager is responsible to prepare and develop a budget that is appropriate for the condo corporation, but in the end, the board reviews it, approves it, asks for whatever changes or revisions the board members feel are appropriate, and as a team, in discussions with the manager, comes to a final figure that the board is comfortable with. The board approves that budget, and then the manager implements it, completes the accounting function, and collects the maintenance fees. The last item on the screen on the slide is about hiring managers and staff. So the board hires and fires the management company as they feel is appropriate. The management company hires the manager if that's the model that you're using for managing your condominium corporation. The board approves all staff policies and procedures, but the manager is responsible for hiring staff, for determining, for evaluating performance, for setting performance standards and schedules. The management company will oversee the manager to ensure that the manager is following the appropriate policies, procedures, and having their performance evaluated. If you as a condominium corporation have on-site staff, superintendents, cleaners, security, anybody like that, the board is responsible for approving the policies and procedures for the staff member. The manager acts as the supervisor and oversees the staff member to ensure that the work is being done properly. So what it boils down to, and this is something somebody said to me 20 years ago, directors direct, managers manage. So managers act on the direction of the board. So the next item we're going to talk about is planning, financial, and other responsibilities. All condominiums run on an annual calendar, an annual budget, an annual report to the owners, and yearly contract renewals. Generally speaking, we work on a calendar year, but the fiscal year it works as well. So a 12-month period, the fiscal year is usually related to the original date of registration. But the best practice for the board of directors is to develop an annual plan that sets out the expectations contained in the budget and pinpoints when the work will be done. And the plan will include the month for the AGM, the dates for the board meetings. It'll identify the renewal dates for contracts and the insurance policy renewal, the dates for routine maintenance, routine communication notices, if you have a newsletter, if it goes out seasonally, and also for information certificates, the periodic information certificate, the annual returns, those communications that need to be completed under the provisions of the Act. Your manager will prepare that annual plan or should be preparing an annual plan for you, but it is something that the board needs to have input into and be familiar with. That's your guideline for ensuring that you're on top of all of the needs and requirements for your corporation. So financial responsibilities. It's important to understand the meaning of community living in a condominium and the difference between condominium living and living in a house. Before you discuss budgets and costs, collection of fees, financial statements, any of that sort of thing, it's really important to understand the difference between the two living environments. Living in a house allows freedom that is not possible in a community living environment. In a house, if you have a leak or a loose piece of siding or a fence that's falling down, and you don't have the money or the inclination or whatever the circumstance is to get that fixed immediately, you can choose to let it go. In a condominium, ignoring things is not possible. Owners expect the building to be clean, orderly, and in good condition. Owners considering resale will want good curb appeal. And as board members, you are responsible to ensure that the property is kept in good repair. So ignoring is not an option. Owners have to realize, though, that their personal financial circumstances and expectations do not and cannot determine the condominium's costs. It's the collective circumstances and expectations of everyone in the condominium which determines them. Owners also have to understand that not all costs benefit all owners equally, even though they all contribute to all costs. The budget for a condominium is set annually. It does not require the vote of the owners. The budget identifies all the services and the costs of running the corporation. One of the conversations that I have often with board members and individual unit owners is that many people look at their maintenance fees as a fee for a service. I'm paying $300 a month, $500, whatever it might be. Why can't I use the gym in the case of the last year with COVID and when gyms have been closed, or whatever the situation might be? And I very often need to remind people that your maintenance fees are not a fee for service. You're not paying rent or paying a usage fee. You are contributing you're contributing your proportionate share of the total cost to maintain and repair property that you own. Regardless of whether you personally are using it every day, you have ownership of a portion of that property, and you have to contribute to the cost of its upkeep. So once the budget is approved, the board needs to send a letter to the owners and a copy of the budget so that everybody knows what the new amounts are, what the new fees are. And condominium fees are calculated, as I think Bilal talked about, Schedule D to the declaration, which indicates the percentage of common interest in the property for each unit. So the condominium fees for each unit are calculated by multiplying the total budget amount by the allocation of the unit as it's indicated in Schedule D. So that percentage of the budget is what each owner is responsible for. And as I mentioned, a vote of the owners is not needed to pass the budget, but if the board is planning to implement a large increase or a special assessment, it is helpful to hold an owners meeting, an information meeting, to let the owners know what the budget increase is going to be and why it's happening. People can accept bad news a lot easier if they understand the reason for it. The bylaws of the corporation will set out how owners are required to pay their common element fees. The industry standard is that owners will pay either by post-dated checks or pre-authorized payment. An owner is required to contribute their maintenance fees, and they cannot be exempt even if they have waived or abandoned their rights to use the common elements, if the owner is making a claim against the corporation, or even if the declaration, bylaws, or rules, or the government restrict the owner from using the common elements or part of them. They still have to pay their fees. If an owner defaults, the corporation has the right to require a lien against that unit owner's, against the unit for the unpaid amount, together with any interest owing and all reasonable legal expenses incurred by the corporation in connection with the collection or attempted collection of the unpaid balance. Should an owner fail to pay, the corporation has 90 days to register the lien to give the corporation priority over the mortgage. While the Act protects the condominium from non-payment by owners, and the collection process will be set out in the bylaws, the Board of Directors should review the process and set a clear policy. The Condominium Act allows that 90-day period. 90 days is the maximum period for registering a lien. The board may choose to make that a shorter period of time. The board may choose to contact unit owners either by phone or by email to let them know if they're late in their payments of their fees. But the board needs to be aware of the legal process, the restrictions, and then set policies for what works in your corporation. The Act also sets out what corporations can do with the money that's been collected. So two sections of the Act, Section 84 and Section 115, cover this very important aspect. We learn from Section 84(2) of the Act that common surplus, so if you have extra money in your surplus at the end of the year, extra money in your operating funds at the end of the year, shall be applied against future expenses or paid into the reserve fund. And except on termination, that means termination of the whole condominium corporation, shall not be distributed to the owners. So if you, just because you have extra money in the bank at the end of the year, doesn't mean that you get to refund unit owners. You use that money either to offset next year's fees or put it towards your reserve funds. Section 115 guides the corporation on the handling of funds. Corporations are required to maintain one or more bank accounts in its name, designated for general operation, and one or more bank accounts in the name of the corporation designated for a reserve fund account. In general practice, condominiums usually have one bank account for operations and one bank account for the reserve fund. Property management companies generally contract with one financial institution to procure the best interest and the lowest charges on behalf of their clients. And that's why if you do go with a professional management company, you will be required to use their financial institution that's used for all of their corporations. Common element fees should be collected on the first of the month and deposited into the operating account. And then a transfer from the operating to the reserve fund for the reserve fund portion should be made no later than the following day to meet the requirements of the Act. The board of directors will be required to sign the bank authorization documents, to set up the bank accounts, and designate the signing officers. To ensure timely utility payments, 9 times out of 10, hydro, gas, water, the utility payments, even phone lines, don't allow enough time for payments to be made by check, signed physically, and then sent out by mail. So to ensure timely utility payments, most corporations utilize pre-authorized payments, the PAP system. With respect to other payments, there's generally 3 options with regards to signing corporation checks. 2 directors on the board could sign the checks. Second option would be 2 authorized officers of the management company sign each check, or 1 director and 1 authorized officer of the management company. In most cases, all directors, all members of the board are given signing authority with the understanding that the treasurer is the person who would most often be called upon for signature. This ensures a continuity of understanding of the payments, but if the treasurer is absent for some reason, then any one of the other directors could sign in his place or her place. So option 1, 2 directors signing the check, is rarely used as it's the most risky. When 2 directors on a board have access to the funds, there is more likely a chance of collusion. If that happens, obviously that results in a loss of funds to the corporation. Sad as that is, it does happen. And in order to reduce the risk, it's not a popular option. Option 2, 2 authorized signing officers from the management company, is most often used by townhomes, small communities, small corporations, or common element condominiums where there's very few checks to sign each month and where it's a challenge to deliver the checks to a board member for signature. Option 3, having 1 director and 1 signing officer from the management company, is the most common method used. It reflects a partnership between management and the board, a partnership of responsibility, and also it allows for more timely payments as well. So those are generally, those are the 3 options that have been available till now. We know now with modern technology and programs that are now available, where some companies, I shouldn't say many, but some management companies are offering the option of board approval electronically, and then the checks are produced again electronically and signed by the management company, because the board members have already reviewed the invoices and approved them that way. So that's another option. So approval of the invoices electronically replaces a physical signature on the check, and it becomes a much faster operation with still control being shared between the manager and the board. One thing though, that for proper financial risk management, the site manager, the person who is actually managing your corporation, should never be a signatory on the corporation checks, because that person is issuing payment approvals and purchase orders. So in order to have some fail safes and you want to protect yourselves, you don't want that to be the same person who's signing the check. You want to make sure you've got 2 or 3 sets of eyes on the invoices before the checks go out. So, oh, did I miss something? Sorry, financial statements. Financial statements are usually prepared monthly by the management company. It's industry standard that financial statements are generally submitted to the board by no later than the 20th of the following month. The exception to that might be at your year end. It does take longer to reconcile the books for the year end than it does for the other 11 months of the year. So chances are, if your year ends in December, you might not get your financial statements by the 20th of January, maybe a little bit later. But the rest of the year, the 20th is generally speaking, that's when by then you'll receive them. All board members should receive a copy of the statement, not just the treasurer. But at a minimum, the statement should include the balance sheet, the income and expense statement, the arrears schedule, the bank reconciliation for both the operating and reserve bank account. And then often boards will schedule their board meeting each month for after the 20th of the month so that they can approve the most current financial statement. If that's not possible, if the board meeting is taking place earlier in the month, then you may be another month behind in your approvals, but you should still have received the more current financial statements to review at least. Once the new statements are received, the previous month is redundant. So if the board meets only every second month, then only the most recent financial statements need to be reviewed. The statement doesn't need to be formally approved because it's not an audited statement, and the numbers might change, especially if an item was overlooked and didn't get posted to the correct month and is corrected later. So you want to review the most recent statement at your board meeting. Reserve funds. So a reserve fund is a savings account. It's established by the Condominium Corporation for the purpose of funding the major repair and replacement of common elements and assets. So the Act states that the minimum amount contributed in the first year after registration cannot be less than 10% of the operating budget. The contribution amount that the board of directors determines after that first year has to be based on the reserve fund study. These levels are generally much more than 10% of the operating budget, because at that point, your engineer has looked at your common elements and determined what you need to have in the bank to prepare for those repairs and replacements. Contributions made by an owner to the reserve fund become the property of the condominium. So owners don't receive a rebate of the reserve fund contributions from the condominium in the event that they sell their unit. Once they've paid their operating fee, their maintenance fees that go into the operating account, the amount that gets transferred to the reserve fund stays in the reserve fund. The Act makes it mandatory for condominiums to obtain an independent reserve fund study or an update to an existing study from a qualified engineering firm or other permitted provider every 3 years. The study analyzes the state of repair of the different components that make up the common elements, their remaining lifespan, and project in today's dollars the amount of money that the corporation will need to repair or replace each of the components over the next 30 years. And it's important to know that only expenses for existing common elements can be paid for out of the reserve. New purchases or new projects must be funded from the operating fund. If you're not sure, ask your engineer or your auditor to determine if the expense qualifies. So that's my topics for today. Thank you very much.
We've got some questions for you, Sally.
Sure.
Could you go through the example of a condo deciding to reopen amenities in the context of COVID? For example, board decides the policy patio should reopen, and property manager looks after relevant provincial rules, public health regulations in order to reopen amenities safely. That was just an example. How does it work?
Okay, so in terms of responsibility or process, no, I'll do both. So ultimately, the responsibility for meeting the government guidelines is the board's. So if you decide to open your, did you say in the example what the amenity was?
No.
Okay, so you decide to open
patio.
Patio, okay. So you decide to open your patio. The manager is going to review and research the government regulations, and the manager is going to tell you that at this point in time, you are not allowed to have more than 10 people on the patio at a time, that every time someone goes out on the patio and then leaves, you have to have the railings and the furniture sanitized, and you have to have people sign in and out when they go onto or leave the patio so that you have contact tracing if an incident of COVID arises. Your manager is going to help you come up with ways to implement those policies and procedures in order to be able to meet those requirements. In the end, however, if you don't meet the restrictions imposed by the government, the board will be responsible for, sorry, I'm not sharing my screen now, good.
Yeah.
The board will be responsible for any breach. So what I've tried to explain to most boards is just because you can doesn't mean you have to, first of all, open your amenities.
Yep.
And if you're going to, you need to be prepared to spend some extra money to bring in an extra cleaner or to have someone, monitoring who is out on the patio or who is using the gym or who isn't. You need to understand your responsibilities in those situations.
Yeah, I think it's bang on. Just and key, just because you can doesn't mean you have to.
Yeah, exactly.
Part two of the question, do you have any suggested resources to increase board members' financial literacy, e.g. reviewing financial statements, or is this covered in the advanced course?
So I believe it is covered in the advanced course, yes. But also, again, if you have a professional manager, use the resources available to you there. Management companies have accounting departments. They have professionals who are experienced and knowledgeable, the people who prepare those financial statements. Somebody should be able to come to a board meeting and walk you through those statements and help you to understand better or more. And yeah, I think, sorry, I was just going to say also, I think even through CCI, there's more than likely magazine articles and resources that can be turned to for, to read up on those things.
Yeah, the advanced course does go into a lot more detail on finances. And then there's one question that came in beforehand, which I thought I would ask, which is, how do you know whether your manager is doing a good job? When's it time to find a better one?
That's a really loaded question, to be honest with you. But the bottom line is, when we talk about managers and board members working as a team, that is the first and foremost. The managers will do a much better job if the board starts with a level of trust and support for the manager in their position. To be able to tell whether your manager is doing a good job or not, you're going to look at a few things. You're going to look at, first of all, are they meeting the requirements of the law, right? A licensed manager has to understand condominium law and implement the procedures that are required under the law. Is the manager meeting the requirements of your management contract? Get a copy of your contract and read it through. Is the company providing the service that they're supposed to? And is the individual manager providing the level of and quality of service that you expect? Have a meeting with the manager and or in addition to the manager's supervisors. Talk about the contract, talk about your expectations as a board. Your expectations may be greater than what the contract actually allows the manager to do. You may need to look at a different type of contract or a different type of service or a different human being to fill the role of the manager. You may not necessarily need to change companies. You may not necessarily need to change managers, but it's all about communication, expectation, reasonableness, and understanding each other's roles.
Okay, we're running late, so I'm going to move on. And then at the end, hopefully we've got some time and we can take whatever other questions might come up. Okay. I'm going to finish up and talk on some miscellaneous topics. I added common expense collections, forgetting that Sally touched on these, so I'll be brief, and that's perhaps my bias. To me, it's very much legal for collections. I'll show you why when I get there. I'm going to start with insurance, and with insurance, I'd like to start with a poll, just to again create some context. So Katya, if you could run that, please. And the question is, whose interests are protected under the condo's policy? Is it just the condo? Is it the condo and the owner of the damaged unit? Is it the condo, the owner of the damaged unit, and the mortgagee of that unit? Or is it the condo, the owner of the damaged unit, the mortgagee of that unit, and all the other owners? And when we finish off, I'm going to challenge everyone to dig up their last insurance certificate. Typically goes out with your AGM package, and see who it's made out to. Who are the named insureds? Okay, Katya, shall we wrap it up? Okay, so I've got 47% is the condominium, 26% are the four parties: the condo, the owner of the damage, the mortgagee, and all the other owners. And actually the answer is that last one. If you look at that certificate of insurance, you're going to see it's made out in the name of the condo, all the owners, and all the mortgagees. Those are your interested parties. So where do we go with this? Again, I'm touching on this. The advanced course has got an entire 2-hour session just on insurance. I'm going to give it 5 minutes. Insurance is taken out in the name of the condo, the owners, and mortgagees. That's who that insurance certificate is. It is made out to. It covers the common elements and the unit, but the unit is limited in the sense it doesn't cover betterments and improvements. Now, how do we know what is a betterment or an improvement? And this is where something called the standard unit definition comes into play. All right, I don't think about this. There was a question that came up about standard unit in the regular context of maintenance. Don't look at it that way. Look at it in the sense of insurance and insurable loss. What's going to get repaired? Because the Act says you determine a betterment or improvement to a unit by reference to your standard unit definition. All right, if you're pre-2001, this didn't exist. So you would have had to have passed the bylaw. Post 2001, it could either be a bylaw or a schedule put in place by the developer. And what gets covered is everything. It's full replacement cost coverage, subject to a reasonable deductible. Unit owner insurance is not mandatory typically. The exception is the vacant land condo, where the condos, the corporation's coverage doesn't cover the structure on that that gets built ultimately. But typically, unit owner insurance is not mandatory. But please go to your community, encourage them to get it. It's not expensive. All right, the condos coverage does the heavy lifting. The condos coverage does that rebuilding, does the rebuilding cost, or rebuilding responsibility. So the owners should have it, and you really want everything to be seamless. When something happens. So, the corporation might go and do the heavy lifting, but the unit owner still needs a place to live. All right, that's on the owner's policy. Or maybe the owner is responsible for the corporation's deductible, and the deductibles are going through the roof. It's made the news repeatedly. They can get coverage over that. That's on them. Betterments and responsibilities, that's on them. So they need to get this. The last thing I want to say on insurance is the need to manage insurance risk. As I said, we're hearing more and more about the cost of insurance, the availability of insurance for condominiums. Deductibles, again, going through the roof. It used to be a typical deductible might be $2,000. Now it's not uncommon to see $200,000. You need, you need the coverage on that, but B, more importantly, as a condo, you really want to manage that risk. You want to stop it going to that level. The Condominium Act only gives you two tools to manage insurance risk. Number one is recovery of your insurance deductible. All right, and now the Condominium Act only goes halfway. I really don't like what the Act says. It's Section 105 sub 2 allows you to recover from an owner, but you must show an act or omission. To me, if you've got to show an act or omission, you're asking for a fight. And if you're talking a low deductible, it's not going to do anything because the condo is not going to fight that because you're going to eat it up in legal costs. But Section 105 sub 3 says you can pass a bylaw. You can put a bylaw in place to extend the circumstances as long as there's no act or omission on the part of the condo. All right. So for 20 years, we've been drafting bylaws that look to the source unit. And it's strict liability. If it came from your unit, it's charging it back. Very, very easy. Couple of things on that. Change to the CAT down the road, that it's still to come, is going to be a challenge on chargebacks. So if anything's thought to be unfair, it can be dealt with there. Also, there's a possible change to the Act coming. I hope it never gets here, which says if you want to do the strict liability approach, just charging back to the source unit, you've got to have that in your declaration. So on that one, if you ever do open your declaration, put it in now. It's a lot easier to do it now. It's 80% change. After that change comes in, if it's not varied, it'll be a 90% change. The second tool is the standard unit definition. All right, then again, I spoke about this right at the beginning. The standard defines what are betterments or improvements to the unit. So by extension, it describes the unit as it will be covered by the condo's policy. There's a lot of talk about going bare bones. Unit boundary might be the concrete to the drywall and the backside of the drywall on the walls, inside of windows, doors, etc. That might be hypothetical unit boundary. Now, if you just take the unit back to that, i.e. the condo doesn't really cover anything in the unit, what's that doing to the mortgagee's interest? Because the mortgagee wants to be able to sell the unit if necessary. So what I really urge you to do when you think about a standard unit definition, certainly bring down the level of finish. Find that minimum level that you want to achieve, but it should be usable and sellable. Very important. If you go on CCI Golden Horseshoe on their website, it's got we do a condo talk series. These are luncheon talks, and there's 2 of them on insurance and how to manage this risk. Very worthwhile. Next topic: status certificates. You think about due diligence in the purchase of a condominium. How difficult can it be? Well, the problem is not the title search; it's the off-title search, and that's the status certificate. In my view, it's the most important part of due diligence when you go to buy a condominium. It provides a snapshot of what's going on. You're buying shares when you buy a condo, you're buying shares in that in that entity. You're buying a share in the liability that goes with it, the risk, etc. You want to know what's going on, and not just with respect to the specific unit you might be buying, but the whole. And that's where the status certificate comes in. It provides a snapshot on the day it's signed. Now, when you get a request, you've got 10 days to turn it around. That's from receipt of the request, and that should be in writing, and payment of the $100, and it's $100. And it's $100 inclusive of tax. So this was established, well, it came into effect May 5th, 2001. I remember discussing this at the ministry level in 1996, and it hasn't been raised. And when you factor in HST became, or GST became HST, it's actually gone down. It's a gift as far as I'm concerned. You should be ordering 2 of these with before any purchase. One when your deal is still conditional, and one prior to closing. It's critical to understanding what you're buying into. We're seeing more and more a fee above the 100, but that's in relation to delivering it faster than the 10 days. You're paying, anybody paying more is paying for that service. It's not illegal. The information on the status certificate, as I said, it's about the unit, it's about the corporation. The unit will identify which units are included, what the monthly common expenses are, whether that unit's in arrears, etc., whether a lien's been registered. With the corporation, it will go into are there circumstances that will result in an increase in common expenses? Section 12, that is the biggest section in my view of the status certificate. Is the is the budget accurate? Are there any special assessments? Reserve for the reserve fund study, is it being funded? Is it anticipated there's going to be enough? Legal actions, do you have the insurance? And then there is everything else that goes with it. The status certificate itself is 4 pages, and it's prescribed. Don't mess with it. The government gives you the form, it's fill in the blanks. But then there's everything that gets added to it: the declaration, the bylaws, the rules. You might have shared facilities agreements, Section 98 agreements, insurance certificate, the budget, the audit, all that goes with it, and all that needs to be reviewed and understood. When you purchase, if there's a note about legal proceedings, you want to pick up the phone, call Sally and say, Sally, what's this about the legal proceedings? And she might shrug and say, call the lawyer. And you have to do it. It's part of that. It's part of the due diligence. I mentioned about the prescribed form. It is. Don't mess with it. There's a question often comes up. Well, we've got asbestos, or we discovered asbestos in the building. Do we have to note it? And I want to stress this: there is no place on the status certificate that talks about latent defects in the structure. Now, if the discovery of asbestos might result in common expenses increasing, that would trigger that paragraph 12 I was talking about. It's financial. It would be, and just in case that disturbs you, it would be on the vendor of the unit to advise the purchaser. It's their duty, not the condos. The condo's duty is strictly the status certificate in its prescribed form. If you change it, you change your risk, and you don't want to change your risk. As far as the board goes, very often the board will delegate this to management. If you've got professional management, usually it's in the contract that management will issue and sign off on the status certificates. They get to keep the $100. Don't dispute that. That's the best deal you've got going for the risk involved. But as a board, you should still be aware of what's going on. Review it at least, I would say at least annually. But if anything changes, if you've been sued, ask the question of Sally, how does the status certificate need to change? And that you might need to go to the lawyer to get the wording for that. If you've got a big construction project that was not anticipated, caught you off guard, it's going to impact money. How does that need to be reflected? So you really want to make sure it's there, because if it's not there, people buy in relying on what's being said or what's omitted, and they can rely on it. And if there are omissions, it's deemed to be that there's nothing there. No common expense increases, no special assessments, etc. So you want to be very careful. Common expense collections. I'll just touch on this very briefly. This is near and dear to my heart. I see this as a very much a legal process. The courts have underscored the fact that it's a legal process. Common expenses, as Sally mentioned, they're the costs that the corporation incurs in carrying out its duties and responsibilities. All right, so when you think about the condo as government, these are your tax dollars. If you want to think about it as a business, this is your cash flow. All right, you need the money to come in to pay the money that goes out. So if somebody doesn't pay, it does impact you, especially if you're a smaller condo. Now, the Act gives you a fabulous tool called the condominium lien, but it's got to be done properly. It's a legal process. Now, if you look at this chart, where's my pointer? If somebody misses January, the lien is automatic. It's just boom, it comes up. And if that staff certificate gets issued, it reflects the fact that the unit's in arrears, but no lien has been registered. The lien still exists. It's statutory. Sally brought up best practices. I really like to see reminder letters go out. They're completely optional, but they go to reasonableness. These will be sent out at the management level. And then the legal process starts here with a notice of lien. It's a prescribed form. Don't mess with it. And then you must perfect. I've got up here perfection of the lien. It's got to be perfected within that 3-month window. And it's perfected by registration. And there's certain things that have to be done. You've got to search title. You've got to give notice to anybody that might have an interest in the property. And not just banks. Banks require notice by registered mail before the lien is registered. But think about someone with a spousal interest under the Family Law Act. They're required to get notice. Very important. Don't mess with the process. Sally also mentioned this in her session. You recover the debt, the late payment interest, which typically is 18 to 24%. It's not financing; it's deterrent, and it also you also recover reasonable legal costs. So if it's all kept as a matter of routine, the reasonable costs all stay routine, regular, and you stand to collect 100 cents on the dollar of everything. There should never be a reason to write off common expenses. Last slide. Other laws, and I know it hurt when I found this out. We're not just governed by the Condominium Act. I wish we were, but we're not. When you think about condos, almost every aspect of law can touch a condo. So some of the more obvious ones, the Human Rights Code. You've got a no pet provision right in your declaration, as strong as you can do. And somebody walks in with a pet, hands you a note from their doctor and says, I need a therapy pet. Human rights. I get frustrated by that one. PIPEDA, Personal Information Protection and Electronic Documents Act. How you handle personal information. There's some debate about whether that applies to a typical residential condominium. My own view is it doesn't, but it certainly applies to your property management, which is for profit. Occupier's Liability Act. The condo is deemed to be the occupier of the common elements for liability purposes. I was in a meeting earlier today where the big issue was carrying out maintenance to balconies and somebody fell through. Not a good thing. It's liability. Condo's the occupier, meaning everybody is caught in that. Occupational health and safety, workplace violence and harassment. If you got a big project, let your whoever is responsible to manage it, let them manage it. Don't interfere with it. You don't want to take on that risk. Workplace violence and harassment. We're seeing more and more. Let's call it behavior within a condominium, which is deteriorating. You can't go up to your manager or a director or anybody employed by the condo and yell at them, get in their face, be abusive. All right, it is workplace violence. You can't do it. And it goes on and on. Virtually any aspect. I brought up family law, that hits. Criminal can hit, etc. Much more, this is also dealt with in the advanced course. And that is where I want to stop because this still leaves us with more room for questions. Okay, I've stopped that. Where did Bilal go?
There he
There's
is.
Right, right,
there's
right.
Bilal. So we got one question up, and then there's still other questions that people have submitted beforehand. And I
Richard, I'll
lost.
read this out to you from the Q&A box. The question's from Stephen. Can you comment on owners growing marijuana plants in a townhouse complex? It's legal to use and grow, but the aroma that emanates can affect an owner's enjoyment of their surroundings.
Yeah.
You have anything to
On that?
on that topic?
Put a rule in place. Ever since the legalization was being contemplated, condos have been putting rules, bylaws, deck amendments in place to deal with the cultivation and smoking. Now, cultivation, it's two different things. And you can the courts have already said a rule will do it. So cultivation is just growing, but smoking is smoking. If you're going to go after cannabis smoking, you've got to go after tobacco. You can't do one and not the other. At least that's my view. I think rules have to be reasonable, as Bilal mentioned earlier. So you've got to go after both. And this has been a hard pill to swallow for some communities, because there's that social stigma that goes with drug use, or what was illegal drug use. It's not anymore. It's completely legal. So you, in my view, it's unreasonable to pass a rule to do without smoking, to prohibit smoking marijuana, but not tobacco. And sorry, it's he's talking about growing, and just put a rule in place that would prevent the growing of it.
The other part of that too, though, Richard, is for corporations, if there's a specific unit that is causing a disturbance to other residents, until the time comes when they maybe do pass a rule that can be more strictly enforced. Generally, corporations have a rule that says that you can't disturb the quiet enjoyment of the unit or common elements by other residents. And we as managers, we do use that rule to at least begin the process of notifying someone that they're, whether it's growing or smoking or whatever it is that they're doing, is causing a disturbance. And they need to find a way to do whatever they're doing in a way that doesn't disturb other people. And that, whether that's an odor or a noise or whatever it is, we can at least start trying to control that.
And just on that, there's a case from a number of years back, had to do with, I think it was cigar smoke. And the courts looked at the standard of smoke transmission between units and said the standard is not perfection. All right, so you can't live, with people on either side and up and down and expect not to notice them a little bit. All right, it's reasonableness.
I agree with you both as well. I think for tobacco and marijuana, we're seeing more and more restrictions being put in even in the declaration now, in addition to the rules. And if it is something which is not caused by the generic nuisance or interference with reasonable enjoyment of your neighboring units, as Sally pointed out, that's the default if you don't have any specific rules in place. Otherwise, if the growing of the plant is the issue, then you might consider canvassing some rules which touch upon that. Richard, were there any other questions from your the list that we had ahead of time which you want to get to, or should we wrap up?
Yes. One for Sally. This one made me laugh. Why does it take so long to get anything completed?
Yep, makes me laugh, makes me cry more often. I tell anybody who'll listen that nothing gets done quickly in a condominium, short of emergencies that have to be dealt with because they're emergencies. And I think the reason is mostly because there's a process for everything. Again, this is not the same as, you know, I've got a leak in my roof and I just want to call in a roofer and get it fixed today, or something simple like that. If you have a, you know, a situation, whatever it may be in a condominium, the manager is restricted by laws, rules, policies, procedures, and sometimes we can act quickly, but often, whether it's the manager or the board, we have to go through a process of meeting as a board, of making a decision, of passing a policy procedure, or agreeing on whatever the next step may be, and particularly agreeing and approving the costs that are involved in remedying whatever the situation is. So 9 times out of 10, whatever the situation is, has to go through a process before it can be completed.
Yeah.
And that's unfortunate, but it is reality.
Yeah. A balcony example I gave is being ongoing for 20 years.
That's a bit,
It's crazy. That will end up in court if it doesn't get,
yeah.
It's
And obviously that's an extreme case, although truthfully, there are times when projects do stretch into years because of things that we find out after we have an engineer examine a problem or get into a more in-depth review of a situation, and it ends up being much more complicated than we originally thought.
Yeah. Bilal, any last words?
No, it was great doing this as always with both of you, and thank you.
Okay.
Thank you,
Sally,
Tim.
okay. I just want to leave one last thing. We don't typically cover it in this session, but it's become a bit of a hot topic again in the news, and that's chargebacks. Remember, if you want to charge anything back, you've got to find the authority either in the act or the declaration. So talk to your lawyer, make sure you've got that before you send it to you ask Sally to charge something back, because it puts her in a very difficult spot. Make sure, and again, update. It's not hard to update a declaration when you think about it. Get that done. So again, thank you to the sponsors for tonight. Oops. And don't forget, if you feel there was nuggets of information tonight, go and learn a lot more in the level 200. I think the level 200 course is absolutely fabulous. Personally, there's so much in there, and there's other courses too. I mentioned about the condo talk. The condo talk is done every month over the lunchtime. There was a question asked earlier or asked beforehand about increasing costs due to COVID. Our last condo talk was on that. So go and listen to it. This is all recorded and on the website. Managing insurance is on there. Reopening issues after COVID is on there. There's lots of subjects which are covered in the condo talk. We do need your feedback. Katya will be sending out a survey. Please take time to fill it out. We want to know how we can improve that. And on that note, have a fabulous evening. Sally and Bilal, always a pleasure.
Thank you.
Thank
Good
you,
night,
Richard.
everyone.
You too.